in this part of the country. We've got to be aware of what the battles are and where the battles are going to be fought. I'll tell you about my knowledge of water. I grew up on a dryland cotton farm in southwest Oklahoma. We had no running water. First time we had a faucet that we could turn on, I was a junior in high school. I grew up with no running water. We didn't even have a well because the water was so jippy, so full of gypsum, that we dug a cistern and brought water from Tipton, which was really good water, and poured down in there with scorpions and the mice and flies and all that would get down there with them. When we bathed once a week, by the way, and there were 3 kids in my family. My younger brother, Gary, see, I was telling you the truth about that part, is 8 years younger than I. By the way, he's retired, and I am not. And my older sister, whose name was not Mary, Jimmy Jean, who passed away very recently, who was 5 years older than me. And we did the same thing every Saturday afternoon. Mother brought in the big number 2 tub, filled it with water, heated a pot full of water and put in there until it got at least room temperature, and bathed my baby brother. Then I got in the same water, and after me, my sister got in. That's the way we bathed as I grew up. I was on a dryland cotton farm. If we made a quarter of a bale per acre, we'd survive. Half bale was really good for us. Now, years later, after Lake Altus or Lugard Altus was built in the 40s, the early 40s in fact, we started irrigating down in my home country. And then if we didn't make 2 bales to the acre, something was wrong. We needed to make a lot. But we had to make a lot with 2 bales because we had to buy the fertilizer and the bug killers and all the stuff that was terribly expensive, that maybe put my daddy more at risk than the dryland farm because he didn't spend any money on it. He just planted it, and it either made it got hailed out, or the bugs got something happened. But we didn't have a lot invested. That changed with water when we went to irrigation. But I grew up without water, basically. Gail grew up here. My next experience with water is when I started dating Gail. Quentin, Oklahoma. We picnicked at Quentin Lake and at Lake Eufaula. I then got into politics, where water was really important to folks around the state. And then I got into, in fact, while I was in politics, when I was Attorney General, I spent 7 years working on the Red River Compact, which is at the heart of the question before the United States Supreme Court that Penny mentioned. I know what was meant in the Red River Compact, and what Tarrant County is saying it meant isn't what it meant. It's not what any of us intended, including the state of Texas. But again, time has passed and people have changed and they need water now. That wasn't the problem 40 years ago. But I worked on the Red River Compact. After I got into the practice, I did a lot of work with the Ogallala aquifer people up in the Northwest because they were struggling to find water to irrigate with. Folks out in my home country could actually drill some pretty good water wells for irrigation over around El Dorado and Gould and that part of the country. So water's always been an important part of my life, both personally and professionally. And then one day I got the call from Oklahomans for Responsible Water Policy, who told me that something was going on with Sardis Lake. And they invited me to represent them. And my answer was, I need to think about it. You know, generally when a client comes in, if they'll sign on the dotted line, they got them a lawyer. You know, it kind of works that way. This wasn't like that, frankly, because this was not a client. It was a life commitment. It was going to keep me up at night. It was going to unnerve me. It was going to make me mad. And I knew that. And so I said, let me think about it. And I did. And then I thought about the great challenge, the great opportunity that I would have working with people like Penny, who knows, let me tell you, she knows more about this than I do. The only thing that differs between the two of us, she doesn't have a law degree, but she's got the smarts. She's smarter than I am. And she can tell you more about the law than I can. But it's given me an opportunity to work with Penny and others in that organization and work with people like Brian and those in the tribes that I never worked with before. And I thought, what a challenge it will be. So I called and said, count me in. And my first appearance at fight before the water board was the day the Sardis contract was on the docket. Now, I'll tell you something about another bit of my history. I was the Oklahoman who signed the agreement with the Corps on behalf of the state of Oklahoma to build Sardis Lake. It's my name that's on that document. I went to Washington and signed it in Washington, D.C. So I felt I had a stake in that matter. And I thought I knew what the Sardis contract was all about too. So when Sardis was mentioned, of course, I was interested. As a result of that, I've been involved in or around a number of very important cases that you need to know about. I helped file the very first case, which was against the water board after they voted to sell the storage rights to Sardis Lake to the Oklahoma City Water Utility Trust. I frankly thought it was a bad thing, bad public policy. And one reason I came to that conclusion is that the Oklahoma City Water Utility Trust did not bargain for the contents, the storage rights, and other rights under that contract. Because I think Sardis Lake is worth $1 billion. A lot of money. And Oklahoma City paid about $27 million for it. And that was not a bargained number. It was the number that Oklahoma had not paid for their share of the construction cost of Sardis Lake that went back to the mid-70s. We were not a responsible state government. Sardis should have been paid for long before. But some governors had few or no payments that we had obligated the state to pay. And I thought it was wrong to sell those valuable rights for what was left on the payment of a contract. That's like somebody that has paid a nickel on a 10-cent candy bar, and you say, well, that's worth a nickel. No, it's worth a dime. It's worth a dime. And that's the way I felt about Sardis Lake. So I argued on behalf of the Oklahomans for Responsible Water Policy. And not long after that, we filed a lawsuit challenging the actions of the board. Now, that case was dismissed after the Choctaw and Chickasaw nations filed their lawsuit challenging all of the issues relating to Sardis Lake. And their legal point was pretty simple. You're talking about something we have an interest in, the state of Oklahoma and Oklahoma City. We, the Choctaws and Chickasaws, have a right. No one's adjudicated what it is, but we're going to go there because I think we're being forced to go there. So the nations filed an action in the Western District Federal Court in Oklahoma City asserting their right. Now, an action that I thought was very inappropriate didn't happen, and it affects folks some of you here, I think, as a matter of fact. The state brought a stream adjudication lawsuit against all the folks in in the Comanche, the Muddy Boggy, and the Clear Boggy basins of southeast Oklahoma, which under the law requires everyone who has or claims a right to water to prove their right to the water, so that the court can determine you got water, you got none. You got water, you got a half glass full. The whole purpose was to do it. Now, I hope I didn't vote for this bill when it was passed, and I think it happened after I left there. But the stream adjudication statute, which allowed the state to do what they did, provided that those who make a claim to water have to pay not only their lawyer, because you're going to have to hire a lawyer if you're going to fight for your water, but also the state's lawyer. So they get to sue you, you pay your lawyer, and you pay their lawyer. That bothered me. That bothered me. And that hit. Now, these days, I find that for a while, I've taken issue with things that the federal government has done. In this case, the federal government stepped in and filed a pleading in the state court in the stream adjudication lawsuit and said it needs to be moved over to federal court because there are federal interests involved in the stream adjudication process. And it was moved to federal court and combined in the case filed by the Choctaw and Chickasaw nations. So that was all lumped together. And then the Judge Lee West from Ada, Oklahoma, who knows something about water, by the way, decided that this was a case that could be handled one of two ways. It could go through the normal process that's happened in the western states for more than our lifetimes. And the average stream adjudication case takes 20 to 30 years. People like me aren't going to be here to see the end of that case. Or, he said, we can get the parties together and try to settle it. And he appointed a mediator, a professor from Duke. See, we had Duke out by Altus. That was a community in Jackson County. And I thought, well, he's one of us. And then I found out it was an Ivy League school. And so the professor started to work on trying to mediate the case, which means bring the parties together and see if he can't split the baby. And in all honesty, I did not think that was a bad idea. Because in lawsuits, several things can happen, but most usually there's a winner and there's a loser, and you don't know which one you're going to be until it's all over. So sometimes a half loaf's better than none, and a glass is half full rather than half empty. And so folks tend to mediate or to try to figure out a way that everybody walks away from the table feeling kindly toward what has happened. My dad practiced that when I was growing up. My sister was 5 years older, and we often had to share a candy bar. So the rule in our house was, my sister got to cut the candy bar in two. I got to pick first. Did any of you have that? Yeah, you bet. She cut it right in the middle, is what my sister did. And mediation's like that. It tries to give you both a fair shake. That's still pending. And all of a sudden, a bomb came out of the air and hit on all of us when Tarrant County Regional Water District struck success in their long-standing effort to get water from Oklahoma lakes. Their claim was under, but the claim changed from time to time. The claim that's now before the Supreme Court of the United States is that they have a right under the Red River Compact to a fourth, 25% of the water that is either in the Red River or flowing into the Red River in certain geographical areas. And so their claim was they could get water from Hugo Lake, maybe from Sardis or from other lakes in southeast Oklahoma as a matter of right under the Red River Compact. And Ed and Pike, they've actually over the years filed a number of requests for permits for water from the state of Oklahoma, claiming their need. And Ed Pike, by the way, is a friend of yours. He pays attention. He's one of the board members that pays attention to what is going on. He's active in the Scenic Rivers program of Northeast Oklahoma, but he knows about our water issues, and he's been my friend for a long time. But there have been permits filed by Tarrant County. That means Fort Worth. The Fort Worth area wants water. The argument that they have made is that there are four parties to the Red River Compact: Oklahoma, Texas, Arkansas, and Louisiana. Those are the four states that need to figure out what to do with the waters in the Red River, because it touches the lives of all four states and the people that live here. And back in the 70s and into 1980, those four states got together and agreed that each should have an equal interest in the waters of the Red River. Now, Texas is claiming they have a right to come inland into Oklahoma, not just take out of the river, the Red River, but from lakes and streams whose waters ultimately flow into the Red River. Now, it's interesting to know who opposed them in that effort. First of all, the state of Oklahoma has opposed them vigorously. The Water Resources Board, that I wasn't very fond of or proud of, in June of 2010, I think it was, have been champions in this fight. They've stepped forward to defend the waters of Oklahoma within the body of the geography of Oklahoma. Oklahoma City, who came over to take the Sardis water, is on our side. We have a common enemy, because if Texas gets our water, we all lose. All Oklahomans lose, whether it be the folks in Leflore County or Oklahoma County. Interestingly, the states of Louisiana and Arkansas, who are the other states who are parties to the Red River Compact, filed a friend of the court brief in support of the state of Oklahoma. So 3 of the 4 states have interpreted